Court of Appeals Division 1 is now in session.
Thank you, folks. Please have a seat. All right, and good morning, and happy to be here in person. So for those of you who are comfortable doing so, you're certainly free to remove your masks for this argument, although you don't have to. We are here for oral argument in 1 CACV 20-0443 Ray v. Lindsay, or Ray and Lindsay v. Gilbert. As you know, we do record and live stream these proceedings, so please give your name and the name of your client when you begin. According to the current protocol, you're going to each argue from your counsel table. You're welcome to remain seated, but we do now have these wonderful little podiums with a microphone. So please feel free to use those as well. Should make it easier for you to see the time clock also. According to, you each have a maximum of 20 minutes per side. Although you are not required to use the entire time, we do require that you keep track of your own time, and the clocks on the podium will reflect the remaining time that you have. You're welcome to tell us how much time you want to reserve for rebuttal, but that is up to you to maintain that time. We recognize you may not be able to see the timer well. Hopefully you can by standing, but if you can't, you're welcome to move around so that you can see that appropriately. All right, and I'll try and give you time posts if for some reason I sense that you can't really see your time. Please keep in mind that we have read all the briefing. We've studied the record and we have discussed the case in conference. And with that, counsel, you may proceed.
Thank you, Honor. May it please the court, Jeffrey Gross, Barry Riddell, Justice, representing appellant Ray and Lindsay, LLC. And it is nice to be back. I figured this was the first time this decade that I'm physically in court, so it is a change. For purposes of oral argument, I'd like to rephrase the issue just a little bit. I think it gets us to the same place, but the issue that I'll walk through is can the town, pursuant to ARS section 900-05, which I'll refer to as the development agreement statute, require an owner to contractually waive a 10-year provision, the 10-year limit in 9-243. That's really part of a larger issue, which is does 9-500.05, the development agreement statute, give the city basically power to do land use by contract, and I'll address that if I have time, but I'd like to take a look at this specific issue. And in that context, waiver is voluntary relinquishment of a known right. So the question becomes, how does that apply here? Well, in the land use context, we have a city, a town, that has an absolute monopoly over the issuance of permits, discretionary permits, administrative permits. And particularly in a legislative zoning context, towns have almost a limitless discretion to deny an approval or a permit for any reason, as long as it doesn't constitute a taking of property. And that could be if a developer refuses to enter into a development agreement. Even in the administrative context, like site plan approval, there still is discretion to impose conditions on approval, such as entering into a development agreement. Was
that a condition here? Was that a condition for development of this property? Did the developer was he legally obligated to enter into a development agreement?
No, Your Honor. But this is kind of the process.
So this is an arm's length agreement, right?
No.
Exchange.
There's a difference between a requirement that the developer do it and a voluntariness. I mean, even without an imminent zoning approval or administrative action, as the United States Supreme Court, no less of authority, recognizing Kuntz, the city has leverage because they have this discretionary right now or in the future to withhold issuance of a permit unless the developer agrees to conditions.
Don't all parties have leverage in a negotiation? I mean, I guess my question is, was this development agreement supported by consideration?
That was not argued, Your Honor. I would say, well, if it was, I guess there's a couple of different ways of looking at that. The promise that the developer made was to pay the city $759,000 for street improvements, and agree to a lien on the property. Ultimately, with a perpetual lien like that, those street improvements may or may not have been added value to the property. They may not have been given the developer the same value when the property was developed. Was there consideration in the beginning? I would have to concede that there probably was, because the
isn't that what
developer
we
was
care
getting
about?
streets.
Consideration at the beginning. We don't try and figure out, it's not based on the value later on.
Yeah, so I would concede, yes, there's consideration, but that doesn't mean that there was a voluntary agreement that was entered into such that would override the statutory requirements in 9-243.
Okay,
Well-
so, go ahead.
No, go ahead.
I was going to say, we have a contract supported by consideration, and now you're going to move to a statute that you say can't be negotiated out of an agreement, so proceed with that.
Well, on going down that road, I think there's two different questions. Was there consideration, and was the waiver of the 10-year limit enforceable? Because we don't know that was part of the consideration. There's nothing in the agreement, one way or another, about whether that was voluntarily waived.
Well, there is, isn't there? Because I thought that statute requires that the terms of a development agreement inure or continue and can only be modified with mutual assent. Otherwise, they sort of run with the land. So that's what the agreement says.
It does say it runs with the land, yes.
There's nothing about a 10-year limitations period, right?
Right.
Okay. So how does that get read in to the development agreement, the assessment?
Well, to be clear, our argument is not necessarily that the 10-year limit is read into the development agreement. It's that if the legislature prescribes by statute a way that the city has authority to act, and then provides them ways and means of carrying that out, then that cannot be subsumed by another statute like 9-500.05, the
why
development
not?
agreement statute.
Why can't the legislature go, look, in a situation where it's being unilaterally imposed and there's no agreement, we're not going to let it go beyond 10 years unless the city council or whoever re-ups, basically. But if the parties sit down and work out an agreement, they can. And don't we analyze those independently? Why do we have to mush them together? How is it that they must be?
Well, two answers to that, Your Honor. First of all, if you look at the Aiken-Gardner case, the Arizona Supreme Court refused to allow the parties just to contract for whatever they wanted to contract. We know there are limits on the town's ability to demand, or towns and another party's ability to enter into terms of an agreement. There was public bidding. Here it's, in particular, the 10-year term of 9-243.
But if the legislature wants those terms to apply, it knows how to do that. It
Correct.
can easily have added subject to
Well, correct.
9-243, and then we're off. Then it's the 10-year limit applies.
Right, but
Legislature didn't do that.
They didn't do that, and that's the point. They did in 9-500.05, the later adopted statute. The legislature did say Section 32-2181 doesn't apply. There was another statute in Section 12-1134, which is the Private Property Protection Act. It's 12-1134I, that says that the city and the property owner can waive the protections supplied by that act. The legislature here didn't do that. The legislature here didn't say, as the court recognized in Aiken-Gardner, the legislature didn't say in the development agreement statute, this allows private parties to, in that case, it was ignore public bidding statutes. In this case, it's ignore other protections that the legislature has provided for protection of private property. And it's not just merely the current property owner.
Let me stop you right there. Let's talk about those two statutes and what they protect. Okay, so it makes sense, doesn't it, that you can't contract out a procurement statute that protects the taxpayer against cronyism? Who's being protected there in a procurement statute? Who does that protect?
That protects the public.
Okay.
And
Now
it
let's go-
protects, I suppose it protects other bidders.
Sure. Folks that aren't necessarily part of this development agreement.
Yes.
Now let's go to the assessment and the 10-year limitations period. Who does that protect?
Well, there are three different classes of folks that protects. One is the
How about
property
here?
owner. Pardon?
In this case,
Yeah.
under your argument.
Yes. There's the property owner that's contracting for the development agreement. There are subsequent owners who may acquire the property, and my client was, I think, the third or fourth in the line of owners who acquired the property with
And they
notice of what.
acquired it knowing it had that provision.
No, there was no provision. There was just a lien and there was a lien and an amount.
They were on notice that there was something they needed to look into. There's a lien there.
There was no, if we're going to talk about waiver, there was no indication that there was a voluntary relinquishment of that act. And in fact.
But the obligation was recorded. The amount,
Yes.
you're going to buy this property, you know that you have a debt for reimbursing in a certain amount. I
And
think that's
nothing
what
in
Judge
that,
Goss was
and
asking.
nothing in that recorded document said it would lapse at 10 years.
No, but there was a statute that said, and an ordinance, the town's ordinance, that said
what are the-
adjacent properties, if the obligation is limited to 10 years.
And so you know you're at about 10 years.
But
Pardon?
counsel,
Okay.
are you skipping a step? What aren't there preconditions to even trigger that statute? Whereas the council has to do something in order for that statute to even be in play. I'm having a hard time understanding why that statute's even in play here. It's a discretionary statute for a city council or town council to impose an assessment. That simply didn't happen here.
No, the town council did approve the development agreement with Greater Phoenix Income Properties and the town.
You're saying
The
that
town
is-
council acted. The town council also adopted an ordinance, which it chose not to follow, but it did adopt an ordinance that in large part was followed, except for the 10-year limitation.
So
Based on the development.
And again, my argument is that the statute, the 9243, gives the town the authority and the ways to carry that out. The town instead acted by development agreement. That development agreement shouldn't allow the town and in a private party.
who would be protected,
Well, one of them,
right?
yeah, that's
Isn't that the
protected.
person, I wanted you to get there.
Right.
It's
And
the
there's-
different statutes.
Yes.
Like, I understand you can't negotiate out open meeting laws or procurement laws. Those protect somebody else that's not in the room.
But this also protects ultimate end users. This property is going to be developed, it's going to be sold to end users. In this case, it's going to be residential development. I forget how many people are going to live on there, but maybe 100, there's going to be 100 homes on that property. The end users are the ones that are going to pay those fees, not the developer. The developer is going to pass through those fees.
Well, isn't
Those
that-
end
isn't
users,
that
those end
true?
users haven't gotten any use of the property in that 10 years.
Council,
That was a public
somebody had to
improvement.
build the roads. Somebody had to make the improvements.
Yes,
Those costs are going to be passed on to the end user.
but they're going to be passed on to the
It's
community
folks
as a
like
whole.
Me and you that are going to buy the houses in there, and that we're going to pay that.
But, yes, but it's going to be, they're going to be, in that sense, they're going to be passed on to the community as a whole. Every citizen in the town of Gilbert, through taxes or development fees or some other way of distributing the costs. And remember, for this 15-year period that the property wasn't developed, that property wasn't benefiting at all from the use of these roads. The general public was. The general public is the one that should bear the burdens of those costs, and the legislature has basically made that decision in adopting the 10-year limit in 9-243. With that, I'd like to reserve the rest of my time.
I have one more question.
Yeah, sure.
So the 10-year limitations period statute is 9-243.
Yes.
And it says it covers, quote, any assessment under this section.
Yes.
Is 9-500 the same section as 243? And could they have said assessment under this title?
They certainly could have said that, and yes, I agree that 9-500.05 isn't in the same section as 9-243. But again, my basic argument is that 9-243 provides the way that the city can do this, and a general statute, a later adopted statute that doesn't refer to 9-243, a more specific statute, a statute that the town complains or contends is duplicative, cannot simply subsume that out of the way. 9-243 is the way the town must go about this, so it's not so much whether it was an assessment or not, but whether the town could act initially, whether the town had a power to act from the very start through the development agreement statute and at a very general level without paying attention to other restrictions that the legislature has imposed in 9-243, like the Supreme Court addressed in Aiken Gardner. That'll reserve the rest of my time.
May it please the court, my name is Charles Workin. I represent the town of Gilbert. And since we're here in person for the first time, and you commented on that, Judge Goss, it reminds me of the country song that has the line, "I look so much better online."
My hair is shorter online. I am going to get it cut one of these.
I'm thinner online. Seriously. As this court has recognized in Florence Copper recently and previously in the home builders case, development agreements are statutorily authorized contracts that expand the land use toolbox of cities and towns like Gilbert. The legislature has placed no restrictions on the power to negotiate the terms of those agreements so long as those terms are consistent with other Arizona law. I submit to you that...
Counsel, what if one of those contracts wasn't supported by consideration?
Thank you. First of all, your question reminds me of the statute in Title 44-121 that reads, if I might be able to quote it from memory, every contract in writing imports a consideration. And here we have a contract in writing. There is consideration here, and we don't have to think of it in the abstract because there is consideration here in the nature of benefits to the developer.
And what are they?
They are, the agreement fixes the amount that is going to have to be paid in the future for the infrastructure. There could be savings, consequently, because if I agree with you today that I will pay you for the road you're going to build tomorrow, instead of for the road you would build 10 years from now, when contract price, construction costs go up, I'm saving money by entering into the agreement and agreeing to that fixed amount. And contrary to what my good friend says, the presence of the street can increase the value of the raw land. These are developers. And the property had been flipped and flipped and flipped and flipped. And the presence of the infrastructure increases the value of the property. And it could do so in an amount greater than the cost that was agreed to be paid in the future at the time of development.
Council, and it's undisputed that the infrastructure was implemented, it was built, that the town constructed the improvements and then imposed the lien. Is that correct?
The construction was already complete or was in process when the agreement was made, as I understand it.
I'm curious.
But it's complete now.
But it's.
Certainly.
It's absolutely complete. Okay.
Oh, yes.
Yes. I'm curious if, going back to your comment about who it benefits and fixes the amount, does interest run on
No.
that money? No. it
No.
doesn't. So
No.
it's a set amount in perpetuity, essentially, until it's paid.
Yes.
Yes.
And if I could finish my list of benefits to the owner, I think there's also the benefit in these agreements of being able to negotiate the scope of the work to be done and the cost that's going to be paid. And this record is a blank slate in terms of what went on between the former owner, Greater Phoenix, and the town of Gilbert. We don't have anything, so we don't know what they negotiated or didn't. But it also, for the owner, it avoids going through the assessment procedure. And one of you made comment, I think Judge Brown, you did, about the procedure that is that is required by 9243. That all can be avoided, and the owner can simply say, I agree that you ought to do this, and I will pay that for doing that. And as I've already alluded, it defers payment. And so this developer who's sitting on a piece of raw land that hasn't been developed, isn't generating any income, and is just costing money in terms of at least property taxes, doesn't have to pay for the roads next to it until such time as he goes to pull the permit, first to get the plat approved, and then pull the permit to build the property. All those are benefits. And
You made a kind of a common sense benefit too, which is the value of that land in these flips is increased by the presence of those roads.
Indeed.
And so there was a benefit from the very beginning for the original person who contracted.
Absolutely. And
Council, what about this part? That the town said that they wouldn't, quote, the final plat for any portion of the property, they would withhold permits and municipal services until reimbursement was received.
yes.
Okay. How's that consideration?
Well, that's a detriment. Consideration can be a benefit or a detriment. And I've listed a number of benefits to the owner. That's also a detriment. And it's a benefit, conversely, to the town, because the town wants to ensure that it's going to be paid. And it ensures that it will receive payment by recording a lien. And by the way, the entire agreement was recorded. So when these successive buyers bought it, it popped up in every title report. And the town further assures payment by saying, when you come to the clerk's desk to ask us to stamp the plat, and you ask to pull permits, we're not going to do that for you unless you've paid. That's only reasonable. And that's what was agreed to, if not negotiated. And that does not impose some sort of constitutional taking here. And those claims are gone in this case. And this was not an agreement where withholding of approval of a plat or issuance of a permit was conditioned upon entering into the agreement in the first place. So, this thing has been skewed by appellant's argument in that respect.
Can we go back to just really the statutory interpretation?
Yes.
Just bare bones, let's look at the words on the piece of paper. And it seems to me there's two sides on this. One is 950.500.05 does not accept the 10-year limitation in 9243. And in other statutes, it does. There are exceptions in other statutes. The legislature knows how to do that, but at the same time, the legislature knows how to not create that exception. So how do we read that? And did you see what I'm going for?
I do, Your Honor, and I'll go back to where I was beginning this argument to say that the legislature placed no restrictions on these agreements so long as they are consistent with other Arizona law. This agreement is consistent. It's not inconsistent with 9243 because the clear and unambiguous language of 9243 says that the abatement provision only applies to assessments imposed pursuant to this section. Therefore, it doesn't cover development agreements.
Sorry that our microphone seems to be in the wrong place.
Well, and I must be part Italian talking with my hands.
So, Oh, finish.
And so the legislature did not intend for the assessment statute to be read into or read with the development agreement
And so our
statute.
focus is on, in this section, creates the limitation that we would carry forward to the 500.05.
Absolutely. I'm sorry, Judge.
So you said early on something that causes me concern. You cited a statute that says every contract is supported by consideration. So what if the town had a gun to the head of the developer and said, well, let's go there.
Yes.
Sign it. Is that supported by consideration?
Well, certainly, first
Is
of
it
all.
yes or no?
No.
Okay.
Okay, every contract, I think, is presumed to be voluntary. But we all know that in the law, one can escape contracts or avoid contracts that are the product of some fraud, misrepresentation, duress, which is what you're alluding to. We don't have any of that here. We have no evidence that Greater Phoenix was under any compulsion to enter into this agreement at the time it was made. And Ray and Lindsay wasn't in the room at the time. And they haven't brought as witnesses into the room the folks from Greater Phoenix.
And they haven't challenged the development agreement on that basis, that
Correct.
weight-bearing column.
Correct.
Isn't the argument, it seems to be that the statute by itself creates the duress? And I'm not familiar with any case that says just because you hold an upper hand in that you could impose an assessment, that would make all of these agreements somehow unconscionable or the subject of duress.
Well, first off,
And maybe I've lost you, and I apologize. That's my question. The argument seems to be, but the city held the cards. They could have imposed an assessment, so we had to enter into this agreement to make it happen.
yes, the city can, at the time of development, require construction of streets, even without a development agreement. The city can also, prior to development, go through the process to impose an assessment. So the developer, the owner, knows that someday I'm going to have to pay for this. But now we come back to the benefits of the development agreement, and that is, if I agree now, maybe I can negotiate that the road is going to be 60 feet instead of 66, or this irrigation ditch is going to be tiled or not, and I can negotiate a price, perhaps.
Well, I guess where I was trying to go, and that's why I say I don't think I was clear, is, but that's true in every contract. Each side has some things that are in their favor, and it's negotiated out.
So
That does not make it unconscionable or
No.
the subject of undue influence.
No, and the development agreement statute doesn't give the town any upper hand. It just, these statutes are alternative means to the same end. And there are 4 or 5 different ways to go. The 9243 has 2 different alternatives within it. Then we have the development agreement statute, and then we have the improvement district method as well. So 4 alternatives. I want to speak to Aiken Gardner for a moment. That case is distinguishable because the use of 9243 is not mandatory, because we have these other statutory alternatives. And there is no, more importantly, there's no public policy that dictates that a voluntarily assumed obligation should ever abate. So abatement is not mandatory. Aiken, in this case, are apples and oranges. And Aiken does not govern here. So, we have a voluntary agreement made pursuant to statute, and the terms or conditions or provisions of a statute for an involuntary means of collecting the cost of paving a street is separate and aside from this agreement. The two never come together. So, with that, I'll heed the admonition that I don't have to use all of my time, but I'm happy to answer any further questions.
Thank you, Council.
Thank you, Your Honors.
Thank you. I'll just address 2 points very briefly. First, we've never made the argument that there's duress or there's some sort of unconscionability. It's all within the framework of statutory construction, what the limits are, why the legislative intent that 9-243, those conditions, should not be subsumed into a very general development agreement statute. And that's because, and it kind of goes hand in hand with Council's other point, that there's no public policy in Aiken Gardner that the lien should and assessment should abate. But there is public policy, and that's protection of private property rights, both for the owner of the property, subsequent owners who may take title, and the folks who are going to live there and ultimately are going to pay the bill at the end of the day, separate and apart from the public who is going to would pay a much smaller percentage.
And I get that protection, but it's there when the city uses the assessment process to unilaterally impose this fee. That's not the same as when the owner voluntarily enters into an agreement and gets a benefit, at least presumptively a benefit for entering into that agreement. The same public policy doesn't apply.
Well,
how do we get there?
Again, and it somehow ties into, and I maybe can address that with who's entitled to be protected, but in Aiken Gardner, there was a benefit. There was nothing in the public bidding statute that said you can't do this. There's nothing in the development agreement statute that said you can't do this. But the Arizona Supreme Court said you can't do this, that the public bidding statutes have to be considered along with the development agreement statute. City doesn't have the absolute freedom to contract. They never have had the absolute freedom to contract. They're limited by statute, and one of those statutes is 9-243. So in terms of...
But that statute applied to all of the city's action. The assessment statute, as council has pointed out, only applies to actions under this section, section 9-243.
Yes, and again, my argument is not that somehow the assessment statute should be read into the development agreement statute, but that when the legislature creates a system, creates a statute, giving the city authority to do a certain thing and then provides the ways and means of carrying that out, that statute has got to be given effect, just like it was in Aiken Gardner. Here, the policy might not be public bidding, but it's to protect private property rights.
And isn't it if we just simply say, if you do an assessment under this section, then you have a 10-year, and if you do an agreement, you don't? Aren't we giving effect to both statutes just as the legislature would have intended?
No, and as I explained in my brief, I think a lot better than I can do in 2 minutes, the whole voluntary nature of this is suspect at least, because of the power, the cards.
You say you're not arguing undue influence, but you seem to be going back to,
no,
this wasn't voluntary.
I'm saying that's why the legislature imposed the 10-year limit, because the legislature understood, like it did in in other statutes that pay attention to private property rights, the honor property rights, 9-463.05 with respect to development impact fees, 9-500.13, which says cities have to follow Nolan Dolan and other statutes, 9-500.12, which gives private property owners the right to appeal city decisions.
But isn't the difference mutual assent? I mean, you're protecting someone who has voluntarily signed a document. In one case, and the other, it's an assessment, so a 10-year limitations period makes sense. Who am I? But makes sense.
Yeah, and I suppose my point, I'll leave you with this unless there are other questions. It always gets down to statutory interpretation. What did the legislature intend to allow cities to do by giving us a very general statute in 9-500.05 versus what they very specifically said the city can't do in statutes like 9-243. And it's not a matter of assent and agreeing to it. It's what process does the city have to follow in order to impose this requirement on private property owners to pay money, and what cards do the city hold where they can have leverage to demand that agreement.
All right.
Thank you.
Thank you, counsel. We will take the matter under advisement and issue our decision in due course. The court will stand at recess to set up for the next argument.